The offer lands on a Tuesday morning. Maya sees salary, title, bonus, remote policy. She smiles, then misses the trapdoor underneath the paperwork. She is not careless, she is excited. Like most professionals, she reads the money, vacation, and start date. The dispute clause gets treated like wallpaper. That wallpaper can decide where you fight, whether coworkers can join you, and whether your story ever reaches a public courtroom when work goes sideways. This is not a non-compete. It usually does not block your next job. It changes the arena when your current employer breaks the rules. Mandatory arbitration means you may have to bring workplace claims to a private arbitrator instead of a judge or jury. Different room. Different leverage. NELP says more than half of non-union private sector employers use mandatory arbitration, binding roughly 60 million U.S. workers to that system today. Employers say arbitration is faster, cheaper, and less hostile than court. Sometimes it may be faster. But faster is not automatically fairer. Worker advocates argue the process is private, harder to appeal, and often designed by repeat player employers who know the forum better than you. Maya almost clicked accept, then she remembered her last company changed commissions mid-quarter and called it a misunderstanding. Paused. That memory stopped her cold. Her friend had lost $8,000 that way. Not enough for a solo legal war, enough to feel stolen every payday. The cheat code is not panic. It is a 5-minute scan before you sign, plus one clean question to HR today. Search the packet for these words: arbitration, dispute resolution, class waiver, collective waiver, jury trial waiver, and opt out before signing anything. If you only search the offer letter, you lose. The clause often hides in attachments, portals, handbook acknowledgments, and equity documents. NELP warns class action waivers often travel with arbitration clauses, forcing employees to bring small claims individually instead of joining coworkers together. Here's why that matters. A $200 wage error is annoying alone. Across a sales team, it becomes a pattern with teeth. If everyone must file separately, most people quit before starting. The company does not need to win. It just needs enough friction. Court also creates public pressure. Arbitration can keep disputes quiet. That privacy may protect reputations, but it can also hide repeat problems. NELP reports workers were almost twice as likely to prevail in federal court, with average awards about 15 times larger in the cited study. That does not guarantee your case would win in court. It means the forum can change economics, pressure, visibility, and settlement behavior. So do not treat arbitration like boilerplate. Boilerplate is where companies put the terms they hope excited candidates will skip. Maya opened every file in the portal. The salary letter was clean. The stock grant was not. That is where the door appeared. The paragraph said disputes had to go to arbitration and class or collective actions were waived. Then came the important part. There was an opt-out window, not a negotiation, not permission, a deadline. If she missed it, silence counted as agreement. Some employers allow opt-outs by email or mail. Others do not offer one. Your job is to find out before day one. Maya did not write a dramatic message. Drama invites defensiveness. She asked for process because process questions are harder to punish. Use this line. Is signing the arbitration agreement mandatory for employment? And is there an opt-out process I should follow? If HR says mandatory, ask for the exact document and any claim carve-outs. Do not debate. Get the map first. If HR says optional, ask where to send the opt-out and what proof of receipt they provide. Then move fast. Save proof like your bonus depends on it. PDF copies. Sent emails, delivery receipts. Screenshots of portal confirmations without relying on memory. Firmly, never rely on the HR portal staying open after you leave. The day you need the document is the day access disappears. Arbitration clauses hide in onboarding portals offer attachments, stock agreements, commission plans, confidentiality agreements, and handbook acknowledgments all the time. Equity documents matter because stock disputes can get expensive fast. Vesting, termination timing, and repurchase rights are not casual details. Commission plans matter because one territory change can erase a quarter. If pay depends on formulas, dispute rules matter too. Handbook acknowledgments matter because they look harmless. They feel like receipt confirmations, not contracts. Sometimes they carry real obligations inside. Invention assignment agreements matter for builders, designers, analysts, and product people. Your side project can collide with company ownership language. Onboarding portals create speed. Speed creates sloppy consent. Clicking through 20 screens is still signing if the system records acceptance. Exhale. This is the boring part that protects future you. Boring beats surprised, especially when money or dignity is on the table. Next, look for carve-outs. A carve-out says certain claims can still go somewhere else, despite the arbitration clause itself. The ending forced arbitration law lets workers with sexual assault or sexual harassment claims choose court despite a pre-dispute arbitration agreement. That law does not erase every arbitration clause. It targets covered assault and harassment claims. Other disputes may still follow the contract. Other carve-outs can include trade secrets, injunctions, workers' compensation, unemployment claims, or agency complaints. Read the list, not the headline. Do not assume a carve-out helps you. Some carve-outs mostly protect the employer's fastest path to court, not yours personally. Ask this before signing: what claims are excluded from arbitration, and does the exclusion apply equally to the company and employee? Then ask, does the arbitration agreement include a class, collective, or representative action waiver? That freezes the group claim blocker. Then ask, who pays filing fees and arbitrator fees? If the answer is vague, consider getting professional contract review first. Notice the tone. You are not accusing anyone. You are documenting the rules before accepting a relationship with legal consequences. Maya sent those questions after dinner. She did not apologize for asking. Serious candidates read serious contracts before signing. HR replied the next morning. Arbitration was required, but opt-out was available within 30 days by email to a specific inbox. Maya downloaded the packet, renamed the files, and stored them outside the portal. Not glamorous, very useful later if needed. She emailed the opt-out before her start date, copied herself, and saved the sent message as a PDF immediately afterward. Then she made a folder with offer, arbitration agreement, opt-out proof, commission plan, equity grant, and handbook acknowledgement together offline. That took 14 minutes, less than a lunch break. The payoff was keeping choices open before any problem existed later. What did she gain? Not a lawsuit, not conflict. She gained optionality, and optionality is leverage before leverage is needed. This is the move. You do not need to become a lawyer. You need to stop signing blind at work. If an employer refuses questions, that is information. Maybe not a deal breaker. Definitely a signal about power and transparency there. A report summarized by Business and Human Rights projected more than 80% of private sector non-union workers could face forced arbitration by 2024. The trend is clear. This is not rare legal trivia. It is becoming the default paper trail of modern employment. For job seekers, add arbitration review to your offer checklist beside salary, title, bonus, PTO, remote policy, and severance terms. For high-exposure roles, be extra careful. Sales, finance, HR, security, product, leadership, equity-heavy startups, and roles with sensitive complaint channels. If the money is big or the language feels sharp, consider paying an employment lawyer for a contract review before signing. If you are already employed, search your signed documents now. Do it before a dispute when your head is clear. If you find a clause, do not spiral. Identify the scope, waivers, fees, administrator, carve-outs, and any past opt-out window. If a dispute is active, do not freestyle based on a podcast. Talk to an employment lawyer or qualified legal clinic. Here's your contract scan checklist. Find the clause, find the waiver, find the carve-outs, find the deadline, save the proof. Search exact terms, not vibes. Arbitration, dispute resolution, class waiver, collective action, jury trial, opt-out, administrator, fees, scope, claims, deadlines. Ask exact questions, not vague ones. Is it mandatory? Can I opt out? What claims are excluded? Who pays fees? If this helped, send it to a friend reviewing an offer. And if you subscribe, thank you. It keeps these cheat codes coming. The bigger lesson is simple. The most important term is not always the loudest term. Sometimes it is the quietest paragraph. Salary gets attention because it is visible. Arbitration deserves attention because it controls the battlefield if that salary gets messed with. Today's move: open your newest employment agreement and run the search. If you are negotiating an offer, do it before signing. If you can opt out, Calendar the deadline and send it through a trackable method. Keep proof somewhere you control. If you cannot opt out, decide with eyes open. Maybe the offer is still worth it. But now you know the trade? Read the clause before day 1. Ask the question. Save the proof. That is how you avoid the arbitration trapdoor.